Wonderful. Hey, good morning. My name is Vincent Toe, and I appear alongside Nachita Paure. We are representatives of the Equal Justice Project. We're an organization based out of the University of Auckland's Law School, and we utilize our legal education in order to promote social change within New Zealand. As a result, the Equal Justice Project is proud to support the Citizenship Bill 2023. Now, our submission will be developed in two parts and I will talk about firstly the rule of law issues regarding the submission. Nachita will talk about the issues regarding the historic injustices. Now, the main crux of my submission is that the original 1982 legislation, on a principled basis, was contrary to the rule of law by imposing retroactive penalties onto people born in Western Samoa. Because of this, their procedural justice rights were unfairly abrogated. Now, Section 26 of the New Zealand Bill of Rights Act provides protections against retroactive penalties and is a key part of maintaining the rule of law in New Zealand. Although the New Zealand Bill of Rights Act was not passed by the time the original 1982 legislation was passed, the protection rights against retroactive penalties had been affirmed by the Act instead of created. Thus, the people who were affected by the 1982 Act and Citizenship Act had their rights abrogated. Now, the rule of law is integral to a free and just society. Protections against retroactive penalties allow people to know what the law is and be able to govern their actions accordingly. As a result, the 1982 Act was an egregious abuse of power by imposing retroactive penalties. On a principled basis, the Equal Justice Project thus supports this bill in repealing the original 1982 legislation. Now, I would like to take a moment to address the arguments about retroactive penalties in regards to the current bill. Now, there have been some arguments as that the current bill is also an additional abrogation of the rule of law by creating retroactive effect through this legislation. However, we would like we submit that the current bill, by creating a pathway to citizenship, does not do so, because it does not. If it were to be retroactive in effect, what it would do would be creating citizenship rights in people unilaterally instead of creating a pathway to citizenship. The forward-looking approach by observing prior criteria and applying that to provide a pathway to citizenship is the main reason why this one does not contravene the rule of law. Now, I would like to pass to Nachita for her analysis of the historical injustices.
Yeah. We agree with the purpose of the bill, as stated in Clause 3 of the Restoring Citizenship Removed by Citizenship Western Samoa Act 1982 bill, and that historical context justifies the repeal of the Citizenship Western Samoa Act 1982. Our written submission on the historical injustice at paragraph 2 and 3 states that New Zealand and Samoa have a shared history with the Treaty of Friendship signed between Samoa and New Zealand in 1962, showing a special relationship which continued to migration between the two countries. However, the historical context of the 1982 Act was tied to fears of Pacifica migrants. This was exemplified by police raids on alleged overstayers' homes during a period known as the Dawn Raids. The animosity towards the Pacifica community shown through the deportation of Samoan and Tongan was a part of the racism of that period. The issue with the 1982 Act stemmed from the normalization of discriminatory practices as part of the Dawn Raids, which extended to this act, overturning a Privy Council decision which retrospectively removed the citizenship of more than 100,000 people, as cited in paragraph 6 of our written submission on the historical injustice. We want to acknowledge the precedent set in Lesa and Attorney General, and how the Privy Council had ruled that under the true construction of the British nationality and status of alien in New Zealand Act 1928, Lesa was a British subject under New Zealand law. The passing of this bill will give restorative justice by rectifying past wrong through substantial action. Paragraph 7 in the written submission on the historical injustice discusses the apologies of former Prime Minister Helen Clark and Jacinda Ardern, respectively, on action taken by the New Zealand administration between 1918 and 1929, and immigration laws that affected the Pacifica community during the Dawn raids. Passing this bill will align with former ministers' sentiment. Furthermore, symbolically, this shows that the government has reflected on their actions and shown growth through repealing the 1982 Act. It is important because substantial action like this ensures that the spirit of the Treaty of Friendship is honored. The EJP support this bill because it will have a positive impact on those who were affected by the 1982 legislation and provide further steps in achieving true liberation for everyone in Aotearoa, New Zealand. Thank you. That's all.
Thank you. I have a question. In a lot of the submissions, there have been questions around the bill also applying to descendants. Do you have a view on that? And do you have any views on what the legal implications of that could be?
JP currently does support the application of the bill to descendants. However, we would like to note the cultural competency as a core concern of ours, considering that Samoan familial structures are different from Western family structures. We would like to, we would like to address that further inquiry and thoughtfulness is required to address the fact that that descendants are treated differently between our cultures. So thus further inquiries are required in order for us to support it. Does that address your question fully?
Yes, we've got time for
look, this is a really technical submission more than some of the emotive ones. So if it's okay, I'm just going to get a bit more technical. You talk about retroactive, the bill being retroactive, but isn't it true to say that at the time, no one from that time period had been given citizenship, but the 1982 finding of Lisa versus the Attorney General was the one that opened the door to it. And therefore, the 1982 bill didn't remove citizenship that had been granted. It just removed the ability for other people to apply for citizenship.
No, that's untrue. The effect of Lisa and Attorney General was granting citizenship, recognizing citizenship to people that were born in the time period in which.
But I've read that, and their finding only finds for Lisa and her family. It doesn't award citizenship to anyone else, and that's why. That's the Privy Council one, and that's why it was only given to that family.
All right, I'm chairing. So just so that was a question, and your response.
That's untrue. Lisa and Attorney General had the effect of recognizing New Zealand citizenship and for people born in Western Samoa while it was under New Zealand's protectorate. It was an affirmation of the rights that had already existed instead of being a unilateral granting from the Privy Council at the time. So thus, when the 1982 Act did come into force, it retroactively removed citizenship for people born.
Okay. Thank you.
And if
have you got any other questions?
I won't challenge it here because it's helpful to hear your perspective. How do you feel then about the official advice, say from 2003, that found that the 82 bill didn't in fact breach the Bill of Rights, which is contrary to your submission?
Sorry,
the 1982 bill that removed citizenship was found to not breach any human rights. How do you obviously state that it did contravene the New Zealand Bill of Human Rights, but the official advice to date has been that it didn't. Can you elaborate on that?
Yeah, we respectfully disagree with that submission, and because of this retroactive penalty and further inquiries after the fact, we don't have the resources on hand, have determined that this retroactive penalty was contrary to the rule of law. So thus, the EJP does support this current bill to provide pathway to citizenship.
Any more questions? Yes, Tiana. Yep.
Thank you very much for that very, very clear submission as well, and sort of noting and acknowledging, I agree in terms of your analysis around the Lisa case with the Privy Council about the recognition of citizenship rights. But I was wondering if you had any other thoughts around how this links with international law as we currently know it today. So specifically like human rights laws, whether you're retroactively taking away laws and what the impacts of that may or may not be.
Apologies, I'm struggling to remember the international convention, but we have ratified international covenants in order to maintain the rule of law as a bare and base minimum regarding to procedural rights of subjects within a nation. Thus, it would be compliant with our international obligations to impose this bill.
Okay. Thank you. We have come to time, so thank you very, very much for your. Okay, we've got 2 individual submissions. Next, Alieta Committee in the room.